Technical glitch. We're back at Tamara Lich's bail hearing. Currently, her lawyer is speaking and referring reference material that the other lawyers had used in keeping her back. I'm going to get right into it. As it turned out, the concern was unfounded because the expert opinion was not heard at the bail hearing. And in the end, concern that the defense had objection didn't seem to materialize at the bail hearing, and it was described as a routine bail hearing, and the Crown wanted it special dates. It was set for 5 days. It didn't seem to Judge Dawson that there could be more meaningful information given. Also, paragraph 16, the court outlines the obligation of the court to consider statements before all cases. That is not a suggestion that we were married to. However, if they can be disclosed and they have to consider fairness was applied and failure, that the facts of the, oh God, dude, I'm trying hard here. Okay. The guy says the last thing he wants is a miscarriage of justice. In this case, the two individuals, Tamara Lich and her surety, have been cross-examined. They've been cross-examined extensively. We have the transcripts of those cross-examinations, which are on file. As of yesterday, I was advised yesterday by the Crown that a intent to further cross-examine in new areas, and Your Honor has ruled that the Crown is entitled to do that, and I don't have any issues with that at all. I then sent an email to Mr. Crimji yesterday basically asking to outline the areas as well as documents, records, notes, or articles upon which he intends to rely as part disclosure. And I indicated that the O'Neill and Rothburn cases that he's referred to, if one looks at these cases, the fundamental principle is that when the subject's liberty is at stake, principles of natural justice and fairness are at its highest. I would submit, Your Honor, that that's the case here. That where the decision is about the liberty of Miss Lich, at least in part on the basis of the cross-examination that Mr. Crimji is going to conduct, then there is no reason on the other side of this case. There's no balance here in terms of expediency. Traditionally, what's happened is that we have to have a bail hearing within a mandated period of time, has to take place. Clearly, Crown can't be expected to disclose all of its information under a bail hearing. That's not the case here. These bail proceedings here, this time, or before the court, Mr. Crimji has had 3 prior opportunities to cross-examine these same 2 individuals, and now he has some new material that he wants to cross-examine them on. There's absolutely no reason why, in procedural fairness, when the liberty of Mrs. Lich is in the balance, that he shouldn't be required to provide disclosure. No, but O'Neill, sir, the judge is speaking. O'Neill, Justice Danbrock, a very respected, experienced jurist in Toronto. I read his decision with interest, and I respect all my colleagues, but that guy's been here longer than I have. And as long as you and your role in defense counsel, I know that case has not been overturned or put aside by the Court of Appeal. Paragraph 2122 suggests that there's no obligation for disclosure. We're talking about the realities of bail hearing. A moment ago, I talked about the reality of a maximum sentence. Let's talk about the reality of bail hearing. Up to this point, Mr. Crimji did not know whether or not he was going home a half an hour ago, if I didn't find there on the record, right? So is that not akin to a situation where in a bail hearing, you're saying to me that that there's new disclosure in new areas of cross-examination as a matter of fairness and legal principle? And now the lawyer, Tamara's lawyer, once we are aware that they're going to be permitted to cross-examine Mrs. Lich and the surety, I asked him if he would make it available the areas he's going to go into. And his answer wasn't, I don't have the time. It's too recent. It's too illuminous. That wasn't his answer. His answer was, I'm not going to telegraph my areas of cross-examination. And I can say, having been on this matter with Mr. Krimji for some time, that he in no doubt chooses to rely, as he has in the past, on O'Neill and Rothorn. And O'Neill, if we turn to that now, Your Honor, is a very unusual situation. And as you point out in paragraph 21, Justice Panbro, whom I agree is certainly one of the preeminent in this province, indicates a very unusual fact situation. Firstly, that the Crown cross-examined at the show cause on summaries of these telephone calls. That's the first part. There's already been a cross-examination on the summaries of these phone calls. On bail review, the surety clarifies regarding phone calls in his affidavit. It's right in the affidavit of the surety. And now the Crown wants to further cross-examine it on summaries, and an objection is made saying you have to make calls. And so that is the very unusual circumstance. Justice Dambo refers to Willis in paragraph 8 of the decision. He then refers to the opener of Justice Dawson, stating the general consideration of the final bail hearing and final refusal to provide information on the facts of the case could open up a further, and he agrees with Dawson, and a bail hearing must be fair and subject to review, and rules of natural justice vary by the proceeding. And therein is a key comment by Judge Van Bro. And I say that because he then goes on to look at the additional argument, paragraph 16, which of course is not present here in our case. So on the one hand, he says, all right, you've already got summary, but you've cross-examined on them, and furthermore, you make reference to them on your affidavit, and now you're saying there's no disclosure of the actual phone calls, and that's a problem? I'm not buying it. He goes on to say, though, in paragraph 16, in particular, and perhaps a complete answer to the argument of the accused, justice may receive evidence as a result of an interception of private communication under and within the meeting, and it goes on, does not apply to that evidence. It is plain that Parliament has suspended the statutory disclosure requisite to the admissibility of private communication at the bail hearing. There's a statutory conclusion that he's relying on, and he relies on as a complete answer. This O'Neill case, which has been used and unfortunately followed, I submit, by Judge Mirage, which has been used by the Crown repeatedly, is a case which is so radically different from the case that typically comes up, which is where the Crown attempts to take by surprise a surety, cross-examination with matters that have very little to do with the charges before the court, but everything to do with an attack on the surety. Keeping in mind that the whole point of the surety is to deal with the possibility of liberty or detention of an individual. It doesn't get any more basic in our criminal courts than to take the accused person or their surety by surprise in cross-examination, or for the ultimate prize, where the ultimate prize of liberty is at stake. And O'Neill, in my respectful submission, doesn't justify that. It doesn't say that that's okay. What it says is, unusual circumstances, 518(1)b, to statutory preclusion, Crown doesn't have to do it. And they don't. What happens after paragraph 22? Exculpatory evidence. Okay, so the judge is talking about, by this case, extension. We don't know what it is. Therefore, I have your point on O'Neill. I don't know how much more time I want to take on this. This is judge speaking. So you're saying O'Neill, Lockburn is a lower court, but I see there's another case here. Your Honor, if I may, that paragraph 22, the general thing on the Crown is part of that sentence, but it also talks about whether it bears significantly in favor of the release of the accused. That's right in 22. So Justice Danborough postulates or that otherwise bears significantly in favor of the release of the accused. Are you talking about indirectly inculpable evidence? Your Honor, if I anticipate perhaps another 10, 15 minutes, if I can finish going to Rockburn and Hudson. I need your guidance, and then I'll take a break on this matter, Mr. Crimgy. I will take the morning recess after your submissions. Rockburn is a case decided, this is Tamara's lawyer, decided in 2021 in a Superior Court of Justice, March. Mr. Crimgy was counsel for the Crown in that case. Mr. Lowe was counsel for Mr. Rockburn. What is clear in Rockburn is that the Crown's position is set out in Judge March's decision, that they should not dispose information. They're talking about cross-examination of the surety. It's no longer a situation where we're talking about telephone calls. We're not talking about the procedure, this crazy procedure in Toronto, that was in Toronto, where you had to agree to detention in order to get disclosure. So what the people were doing, the judge is saying that's a long historical. Okay, that's not what we're talking about. Where Rockburn is the very issue that is before Your Honor today, and that is, they had information that they had for a proposed surety prior to cross-examination. Mr. Crimgy at that time relied on O'Neill, the decision of the court. In that case, the Crown asked the surety about certain telephone calls in which he participated that had to do with the suitability of the surety. These telephone calls were not disclosed. It was, as we now know, looking back on O'Neill, a lot more complicated than that. And there's no mention, of course, anywhere in this decision of the statutory requirement that precludes disclosure of telephone calls. There's also no mention of the fact that the accused person had been cross-examined at the show cause and included reference of the summaries in their interim application of the bail review. It's agreed by counsel of the court that there's no obligation of the Crown to make disclosure of all the evidence. However, in that case, defense counsel submitted the principles of natural justice that required the Crown to provide this information in the cross-examination of the surety. The judge is trying to reconcile the argument. It's clearly that this was a bail hearing. The accused was arrested, had to be brought before a justice within several days. You'd expect a synopsis. No disclosure, as we know, that would be provided. There's no obligation on the Crown at that stage. What you're saying here, though, is that because of, well, again, I'm not gonna get into a debate with you whether or not disclosure will be provided at the early stage of the bail hearing. I'm not trying to agree with you in that regard. We're talking about the nature of bail hearings, and I'm not going to go there. This case has gone through, like you mentioned, 5 different judges, 5 different hearings, and you're saying, as a result of that, that any disclosure ought to have been afforded before today in order for you to prepare the client for cross-examination and perhaps the surety? Is that the bottom line? Yes, I hate to use that expression. The judge is saying, well, why else? You want to prepare your client, right? That's what the judge is saying. Tamara's lawyer is saying, I don't accept the notion that disclosure that the Crown has can be withheld for some reason unbeknownst to me. And all they have to do is provide disclosure of the synopsis at the beginning. I don't accept that. And the reason I don't accept that is that it's the very same reason as I'm making the argument today. Mr. Crimgy knows what areas he wants to go into. He knows they're new areas. And he's basically saying, I don't have to give them to you. Why? Why? Because traditionally, the reason was expediency. That's not a point here. Typically, the Crown has no obligation to disclose part of the bail hearing, largely based on O'Neill, which, when we look at it, is a very unusual set of circumstances. In fact, statutorily, the Crown is entitled to not produce. Those things are not in play here. There's no reason why Mr. Crimgy can't take 15, 20 minutes and advise me what areas that he's going into. And then I would then canvass those areas with the surety and Miss Leach, as you mentioned. And the judge is saying, and don't take me, I may be an arrow because it's been a long time since I've been in the Ontario court bail hearing, and maybe things have changed in the past 10 or 12 years. More and more disclosure, especially electronically. I don't want to stray into an item not in my expertise. I have your point down and what you're saying. So what you're saying is Rockburn. Rockburn was, unfortunately, this is the lawyer again, Tamara's lawyer. It was wrongly decided because of its reliance on O'Neill without full appreciation of what O'Neill was all about. The court does mention the case of R versus Hudson, which is a decision of Mr. Trotter, Justice Trotter, of certain bail fame, amongst other areas in criminal law. And the argument by the defense was, very simply, that they should be getting disclosure of evidence relating to the surety prior to cross-examination. And Hudson was relied upon. Wherein Justice Trotter stated there's no justification at the first. Let's look at Hudson. The decision of Justice Trotter, 2011, was in fact the situation that we referred to earlier, where accused persons in Toronto were agreeing to detention in order to go to a bail review so that they can get disclosure. And it was that very strange and an unusual situation, but in the course of that decision, Justice Trotter, regarding, for the most part, it's a shining a light on apparent strange and unfair practice. In the course of that decision, in paragraph 12, Justice Trotter recognized the statement, the systemic pressures in place that ensured the procedure, or for organizational purposes. He then says very clearly, but there's no justification for delaying otherwise available disclosure until an accused person has cleared the first bail hearing. The right to bail in the Charter of Right and the right to Crown disclosure operate independently of each other. Timely disclosure is an integral part of the legal process which clearly trumps other organizational processes put in place by the Crown. The fact is, there is no reason, expediency's gone. There's no reason why the Crown should refuse disclosure. And there's every reason for that disclosure to be made, Your Honor. Those would be my submissions. And that's it. You want me to make submissions now? Okay, they're talking about a break, and is this tangible disclosure the judge is asking the Crown? Do you have some plan of questioning related to the events giving rise in order to challenge the adequacy of the surety and the applicant, or is there something tangible that you just don't want to disclose at this point? There will be, Crown speaking. I don't want you to tell me, because I haven't made a ruling yet, is it tangible or is it just questioning that you want to amplify or challenge? So my friend made a request. He wanted me to tell him what my areas of cross-examination would be, which I'm clearly not required to. No counsel is required to tell the other counsel what they're cross-examining on. There is a tangible video that I'll be relying on that has never been presented before, the judge says. He says no, it's something that the Crown just became recently aware of. It's in the social media. It's not something that the police generated. It's out there in the social media. And I know, Your Honor, that my friend was aware of the O'Neill and Rockburn decisions. He refers to them in his correspondence to me. But he only provided me with his materials this morning after he raised the issue. But nevertheless, the Crown is prepared to move on if he's passing some papers to the judge. By the way, Tamara is not in handcuffs or shackles today. Good news. So, Your Honor, Justice Penbrook is absolutely clear. This is Moez Kemji. If you look at paragraph 7, His Honor reaffirms the very point that there's no constitutional obligation to make full disclosure prior to a bail hearing. And what Justice Dembrick did first through the Supreme Court of Canada decision in support of that portion of law, and speaks to the accused being called upon to elect the mode of trial or to plead. Accusers entitled to disclosure before that. And this case law rejects it, paragraph 8. It states defense counsel argument, and says counsel for the accused is entitled to a more limited form of disclosure. They are They are entitled to the disclosure of evidence to be used by the Crown in cross-examination as a principle of natural justice or of natural procedural fairness. And paragraph 8 is important because 70 says there's no constitutional application. And now let's look at the principles of natural justice. Do they require the disclosure? Particularly of the items to be used by the Crown in cross-examination. And in paragraph 10, and I've highlighted that for Your Honor, Justice Denbrook indicates, I find it to be an odd notion that while the right to fundamental fairness protected by Section 7 of the Charter does not compel disclosure of the evidence to be led by the Crown in a bail hearing, the common law right to procedural fairness does. So, I mean, and he's chuckling. Your Honor knows that an affidavit was filed by Miss Lich. It seems the defense is keen on not having them subjected to cross-examination. And the Crown, pursuant to O'Neill, has the right not to disclose what it's relying on in cross-examination. I mentioned a video, plus there's a couple of photographs. I suppose the judge is speaking. I suppose the challenge in this case, Mr. Crimji, is that we're not at the first bail hearing, so to speak. I'm assuming O'Neill, if I'm wrong, is addressing the normal caution of the original bail hearing or after an arrest. Error. Miles down the road. I understand 2 bail hearings, 2 bail reviews. Is that a distinction? He's asking the lawyer. The lawyer says, no, it's not. The Crown. If it was, Justice Denbrook would have had some indication in his decision of what Your Honor is referring to. He simply makes a conclusion of law. It's odd notion that fundamental fairness does not compel disclosure of the evidence to be led by the Crown. The same thing he said before. Oh my God. Hey, if you want to interact, transfer me some money because I don't make any money doing this. churchofbubbles@gmail.com. Never done a plug before. I'm doing it now. Why not? Spending all kinds of time, and this is really torturous. Losing my hair. The Crown will still advance secondary and tertiary grounds. The Crown is still speaking. Certainly assessment of the risk to the public or the lack thereof. The Crown at this bail hearing stage is entitled to confront the accused. And for Your Honor to witness her response on her feet. Not prepped by counsel saying, this is the evidence of the Crown. This is the way, you're going to be asked questions. The law permits me, O'Neill permits me to do that. And I intend to do that subject to Your Honor's ruling. And it's consistent towards the pursuit of truth at the bail hearing stage. We're not dealing with a finding of guilt or sentencing. So subject to any questions, and even the case my friend referred to. What about Willis? Willis, the judge is saying. Tab 1. What about Willis? Judge Dawson's decision. The judge is asking the Crown. Yes, if you look at... Well, the Crown is saying. Let's look at paragraph 10, though, even though the judge wanted to look at paragraph 16. The justice says, and I'm assuming that Justice Dawson, I don't know if it's a male or a female, should I ask? And the judge says, nope. He says, having reviewed the entirety, I'm not satisfied there's a breach of law of the natural justice. The rules of natural justice were in the nature of the proceedings. This is a bail hearing. This is what Your Honor is doing. Oh, for clarification, it's churchofbubbles@gmail.com. Thanks, guys. I appreciate it. They're all just sitting there looking at one another. I don't really know what's going on right now. In answer to Honor's question, paragraph 16, the answer to that is provided by your brother, Justice Pembroke and O'Neill, where he explicitly considers that issues from paragraph 7 to 10, and he discusses the decision in paragraph 8. Because Your Honor will note that paragraph 8, the applicant was relying on the decision of Justice Nosson and Willis. Sorry. Justice Denbrook's comment of Justice Nelson's decision is that I find it odd, and he's going to say this again, notion that, oh my God, same thing as he said before a couple times. God. Ugh. So, you know, with the respect that the Crown communicated his position to my friend, he's been aware of my position. He is so he's saying, I hope I addressed all of the other dudes' position. There's 3 points being brought up now by Tamara Lich that they're not keen on. That they have, that is not accurate. But we are seeking a fair prosecution. Paragraph 10 that Mr. Kremji referred to in the O'Neill decision, in my submission, leaves the door open. That's the way I read it too. He repeated it 3 times and it sounded to me like it's an odd notion that fundamental fairness is protected by the disclosure, be led by the Crown at the bail hearing. Common law right to procedural things do. And then goes on the basis of the things I've already indicated to make this decision in O'Neill. Both because of the prior disclosure and the cross-examination and the inclusion of the affidavit, as well as the statutory. So I would submit, if anything, that ruling leaves the door open. He hasn't reached a conclusion. He finds it an odd notion on that question that he asks himself. On the contrary, he reached the conclusion based on the particular facts on the case and the statutory preclusions of the exclusion of the. Therefore, Mr. Kremji says that he's entitled to confront the accused without preparation at a bail hearing, whereas he acknowledges that at a trial, certainly the accused person would be prepped by counsel, because he doesn't want to cross-examine Miss Leach or the surety without preparation. My question is, why? Why should there be any less standard here today when her liberty's at stake than at a trial? Why? Why should there be some lesser standard required of disclosure of the Crown when Mrs. Leach's liberty's at stake, as opposed to a trial or a surety? The Crown would understand that Miss Leach, and any other witnesses would be prepped by counsel based on the disclosure that they received. Why should there be a lesser standard today? Her liberty is more directly at stake today than it is even at trial. Those are my submission, Your Honor. Thank you, counsel. 20 minutes, guys. He's coming back in 20 minutes with the ruling. Okay, Madam Reporter. Okay. All right, everybody standing up. Tamara's wearing a sweater. She doesn't have a mask on or anything. A black T-shirt. The only person with a mask in the court is the 10-1. Recess. Oh, people are singing recess. Recess. The judge is going, that's enough. That's enough. No, they're saying it still. Ah! They're singing, going out. There's about a dozen of them walking out. Tamara Lich is going out. The lawyers are still there. And somebody in the audience was going, recess, recess. And the judge was going, no, hey, look, I love her. She's sweet. Okay, folks, so we'll be back in about 20 minutes. When you share this out, please put a title along with it. It helps. And if you like the comments and respond and all that stuff, it helps more people see it. And it's good, too, when you come on, they do different metrics in order to make sure that this gets shared out to the public. So anything you can do to support the sharing of this information, which you will not find anywhere, by the way. The media isn't covering this at all. Nobody knows. Yeah, we will be back in about 15 minutes. Thanks, guys. Appreciate it very much. Church of Bubbles loves you.